Hey, you there.
God?
Yeah, you in the purple sweatshirt.
Who is this?
I am the ghost of the criminal cases. Are you trying to rob that car?
What's it to you?
Do you even know the trial that you will face after trying to get into that car?
No.
Well, you'll see in a second, Mr. Jack Gleason.
Oh! What the? What are you?
I'm the ghost of criminal cases past.
What are you doing here?
My purpose is to see why you're really robbing this car.
Nothing in my past led me up to doing this.
Oh, you will see.
What? Where are we?
We're 20 years ago in your past.
What are we doing here?
We're finding out why you were trying to rob that car. Let's take a look.
Such a good baby, aren't you, Jack Jack? I want to show you how to commit Grand Theft Auto. It's unlocked.
This can't be true. Like, what is this?
It is true, Jack. This was your past. Now we must go back to the present.
No. Ugh. Dude, you gotta stop. What the? Oh, I must have just been imagining all that. God, it's stupid.
What are you doing?
After
After I just showed you your whole past, and you're still trying to break into the car?
yeah?
Jack Gleason, we must show you your future.
No.
Ow!
What are you?
I'm the ghost of criminal cases yet to come, and I'm taking you to your future to see what happens when you commit this crime.
What is this?
Too far, too far.
What the?
Order in the court, order in the court. Today we are gathered to start the trial of Jack Gleason. As of right now, 48 hours ago, Jack was caught trying to rob a car and is now being excuse me, charged with robbery of a vehicle. He is on no bail or bond, and we will meet up in the following weeks.
Please stop.
Now do you see why you shouldn't commit this crime? You'll be in jail.
Yeah.
Dude, that's supposed to tell me not to rob this beautiful car. I didn't even understand what he was saying.
Alright, cut. So if you're like Jack and you didn't learn the lesson, let's get into the nitty-gritty. But don't fall asleep, because this is for sure gonna be an eye-opener.
Dude, that's 20th Century Fox. We can't use this.
Okay, fine. Let me change the channel. Now, you're a criminal. But depending on what you do, you can be tried differently. 2 different ways to be tried is a misdemeanor or a felony. A misdemeanor is any lesser criminal act in some common law legal systems. Misdemeanors are generally punished less severely than felonies, but theoretically more so than administrative infractions and regulatory offenses. Many misdemeanors are punished with monetary fines. Examples of misdemeanors may include petty theft, simple assault,
Sure.
public intoxication.
I believe in magic!
Now, leading to felony. A felony is defined as a crime that is considered to be more serious in nature. In criminal law, a felony is a category of crimes that are often classified as the most serious type of offenses. Felonies can be either violent or nonviolent. Felonies include, but are not limited to, the following: murder, aggravated assault or battery, arson,
Louis? My tree.
So what's the matter with you?
and there's a lot more. So, you're about to perform one of these crimes. You're a criminal, but you're a very bad criminal, and you get caught. You're busted. Now, you will have to go through the system.
The discovery process is when a defendant and prosecutor trade information about their cases. This includes information about the evidence that the prosecutor has and plans to use against the defendant, such as background information, witness statements, and police reports. Before a trial, pretrial motions may be filed by the defense, which may greatly alter the charges being faced by a defendant, or in some cases have them dismissed outright.
Alright, so next up in the criminal process is a pretrial conference, which is basically a meeting between both the prosecuting attorneys and the defense attorneys to discuss pretrial motions and other trial-related issues. After the pretrial conference is complete, plea agreements are next on the agenda. Plea bargains are an offer made by the state that gives reduced penalties and charges in exchange for a guilty plea. If a plea agreement is made, it must be put into writing and submitted through the courts. Then the defendant will stand before a judge to make a statement, and the judge will decide whether or not to allow the plea deal. If the judge agrees, then a sentencing trial is set where they will then sentence the defendant according to the plea deal terms. Sometimes a judge will deny a plea bargain, in which case a trial is then set.
Pretrial upon pretrial, defendant is innocent until proven guilty. Trial that all evidence is presented and a guilty or not guilty verdict is reached. As for pretrials, a defendant has the right to trial by jury, but may request a bench trial instead. A bench trial is a trial without a jury in which the judge is the sole decision maker of the defendant's verdict. A bench trial is only granted if the prosecuting attorney, judge, and defendant all agree to one. Sentencing trials after a guilty verdict is reached, whether at trial or through a plea deal. A sentencing trial is scheduled within 20 to 30 days. At a sentencing trial, a judge will hand down the final sentence orders, including the penalties for all charges. If a defendant is sentenced to jail or imprisonment, they are escorted by law enforcement directly following trial. If they are not sentenced to any form of incarceration, they are released on court orders and post-trial terms.